regard to gender equality, I think that dialogue, the more men that understand the issues relating to women, um, that's a very important dimension.
Absolutely. But it's 5 o'clock and we like to get started on time. So, good evening and a very, very warm welcome. So, as Payal has said, our equality is in our own hands and the law helps those who are willing to help themselves. I am Sukirti Gupta. I am the co founder of Sipping Thoughts. A little bit about Sipping Thoughts before we proceed. Sipping Thoughts is a multi platform media company that was set up by me and by Meeta Gudgutia. It was set up keeping in mind the tagline Real Women, Real Thoughts. We are a no judgment platform where we want to create a network of women for women, and of course, for the men that have supported us. Sipping Thoughts reaches to about 2.5 million women on a monthly basis. We're available on Instagram, we're on Facebook, we're, of course, on our website. Do check us out. I'm sure you'll find lots of interesting content for you to actually ponder over. In this session, though, we're going to learn about real life stories of women that have shaped our laws, the sacrifices that have given us the rights that we enjoy. And yes, we reiterate the law helps those who help themselves. So today we're going to find out a bit about our legal rights. We've got with us my good friend and the founder of Just Contractors, Payal Chawla, who has got a master's degree from the University of Chicago, and she's also an alumnus of the Faculty of Law, Delhi University. She has worked as an in-house counsel with Coca-Cola, Reckitt Benckiser, and was also a partner with HSA Advocates. She has been named one of the thinkers to watch out for from Forbes India. She has also served on the Judicial Commission headed by the Hon'ble Justice Usha Mehra in the Nirbhaya rape tragedy. And her life and work were captured in the form of a short biopic by Tapasya Productions, which has won accolades at various festivals, including the Dadasaheb Phalke Film Festival in 2017. In addition to her legal practice, she has a deep academic interest in arbitration and writes regularly for reputed publications. So, first of all, Payal, welcome to Sipping Thoughts. We're really excited to have you here.
Thank you, Sukirti. Thank you very much for having me this evening.
So, I'm going to get started. And I think the first question, of course, I love to learn a documentary that was really made about you and your life. Please do tell us more about that. That what was it that the movie makers, and especially when they're making a documentary, thought that they wanted to capture?
Um, Actually, Sukirti, when the filmmaker Mr. Ajay Chitnis contacted me, he had heard about my litigation with this corporate giant, and he wanted to know about that litigation. So, but by the time he had contacted me, I'd already lost the litigation. So I was like, sorry, but too late. There's no story here. It's dead. So he said, no, but I'm interested in, what it took to fight a corporate giant this size. And that's the story we're interested in. But as he, learned more about my professional and private personal struggles, and then, in a sense, the icing on the cake was starting my own law firm, Just Contractors, which is an all-women law firm. He then turned it into an inspirational, very positive story for young people who may want to learn a little bit from the aged like me. So,
Now you're begging me to ask the question, because why an all woman law firm?
initially when I started out Just Contractors, the whole concept and idea about starting an all women law firm was really very personal to me and my needs at that time, because I'm a single mom and I needed to be home at a particular hour. So I had this idea that I wanted to create this platform where women could have a space where we could work within our own hours and yet balance, do this work life balance. So I spoke to friends, and all my well wishers were like, Payal, you want to do corporate law? Please do not. This will be committing professional suicide, because nobody is going to take you seriously. They're going to think about you as rabid feminists. And you're coming at it from that point of view. So, well, I took advice. I kept this idea in my head, but I quietly kept hiring women. But over the next 3 years, I had uh, such a positive experience. So one, we were making money, we were getting recognition, we were getting awards, we were winning our cases, and then the comfort level of working with women was so brilliant. And I thought, and at the end of 3 years, when we were cash flow positive, and I said, you know what, I don't want to hold this back anymore. We're corporate lawyers, we're competing with men on their own turf. This is a male dominated field, and why should I not be screaming about this? So that's what, and one more thing that I do want to say, I think that what I had not catered for, and what turned out to be one of the most, for me, the most gratifying experiences setting up an all women law firm is the sisterhood that it has created within the women that work within in-house contractors, the support group that they are to one another, uh, and and honestly, the pride in actually competing with men on equal terms, that's what's so gratifying about this. I strongly encourage everyone to have all women businesses.
You're definitely giving all of us some food for thought, and that yes, it is possible. Yes. But now, one question, of course, and I know this is the burning topic. I'm sure you're getting asked this question everywhere. This latest judgment that's happened on
Yeah,
POCSO.
of course.
What are the facts? Please tell us. I know we want to get started with the topic, but we definitely want to understand a little bit about what's happening with the Bombay High Court, what's happening with the Supreme Court. It seems like there is so much information out there.
When I started preparing for this lecture, I had planned the entire history and had no idea that this judgment was coming, but then it's got the imagination of the entire country. One good thing that's come out of it is I think a lot of people have heard of POCSO now.
At least we all know that there is this term called POCSO.
It's POCSO. So anyway, just to tell you the facts, there's a little child of 12 years old. She's gone out of the house looking for a guava. She's met by a neighbor who lures her into his apartment, saying he's going to give her the guava. He takes her in there, he touches her breast, and he attempts to take out her salwar. The child screams. The screams are heard by another neighbor. Meanwhile, the mother is worried because she's gone to get a guava, she hasn't come back. So she kind of goes looking for the child. She's screaming her name. And while she's looking, she is met by the accused. She asks, have you seen my child? And he says, he denies it, says she's not at my place. So the mother runs down the stairs and then she runs up the stairs and she finds the apartment of this gentleman. Not sure that's the right word though.
I know. I don't think we want to call him a gentleman, but TK.
She finds his apartment bolted from outside. She opens, kind of not unlocks it, but she opens the bolt and enters and finds her child crying, who relates the story to her. They immediately go, they lodge an FIR, and so these are the facts. Now, the trial court in this actually charged the accused with four things. He said there was an offense under Section 7 of POCSO. I'll come to what that is. It defines what is assault, what sexual assault is, and punished him under Section 8. The punishment for sexual assault is in Section 8. He also punishes him for under Section 354 for outraging a woman's modesty, for charges him with kidnapping, and charges him with illegal confinement, wrongful confinement. So, and he gives him rigorous imprisonment of 3 years. And
And this
I'm
is by the lower court, right?
by the lower court. It's the extra joint additional sessions judge, Nagpur. So the matter is then appealed and it goes to the High Court. Now, one of the important things about what's happened in the High Court is that the court does not disagree with the facts. At no point does the High Court say that, look, we disagree with the facts, or this fact was incorrect, or we don't believe the witnesses were not credible. So the facts are taken as it is. But two things are done. The court's silent about kidnapping, so the kidnapping charge is just done away with. There's no explanation as to why that happened. And also, the court says that, this is what the finding of the court is. The court says that because under POCSO, sexual assault has a punishment that ranges between 3 to 5 years, and it's a higher, more stringent punishment than outraging a woman's modesty, which is 1 to 3 years. There would be a higher standard of proof required, and therefore does away with the POCSO charge and holds him guilty, gives him a 1 year punishment for on the grounds of outraging a woman's modesty.
Now, Payal, I want to ask you this question. When you said that, first of all, the court did not challenge the evidence, so why did they say that a stricter or that more evidence was required? I think this has become so confusing because, on one hand, you're saying, listen, we believe the evidence. And then on the other hand, you're saying you want a stricter level. So, what does that mean to the normal public?
I think everyone's struggling with that question, frankly. And I think one of the reasons the Supreme Court stepped in just on the statement of the Attorney General. The Attorney General made the statement, that he found the findings, the conclusion disturbing. And the Supreme Court immediately stepped in and stayed it. Because, so from my point of view, actually, I went through POCSO. There is really no requirement of a higher standard of proof. In fact, there's a section 30 under POCSO which says that there is a presumption of culpable mental state on the accused. There's actually, so it's a rebuttable presumption. The accused can show that he didn't have a culpable mental state, but that presumption is there. And to me, what I find a little bit, I actually, can I just take a second and read to you what Section 7 is? I think it's
Please
very
do.
important to the audience too. So I'm just going to bore you a little bit, but I want to read it. It says, whoever with sexual intent touches the vagina, penis, anus, or breast of a child, or makes the child touch the vagina, penis, anus, or breast of such person, or any other person, or does any act with sexual intent which involves physical contact without penetration is said to commit sexual assault.
So then, how did the Bombay again court say there was skin to skin contact required when it's so clearly written?
Absolutely, you're right, because there's no requirement of skin to skin contact. So imagine if a perpetrator was to use a gloved hand to touch the private parts of a child. Or I'm taking this one step further in saying, what if he's wearing a contraceptive and has the child touch his genitalia? Are we saying that's not sexual assault? It's baffling to me that, remember that POCSO has come in because this is a special legislation which was brought in for the protection of children. Because when you're talking to a child, extracting information from children is not, it's not a job you and I can do. It has to be people who are trained in this. There have to be guidelines. How do you talk to a child? Because, you know and there's just so much stigma around. I mean, are they doing the right thing? Children begin to question themselves. So, I mean, that was the intent to bring about POCSO. And in my view, if anything, it has to have a higher, a lower standard of proof, as opposed to, uh, I mean, I disagree most respectfully with the judgment.
No, I know a lot of us have because they felt that each step forward for women rights are actually two step backwards. These rights don't come easily, and it seems that every step of the way that women had to fight for them. So that each pro woman enactment that has happened has literally, there has been a lot of sacrifices of women, and you're going to talk to us a little bit about this.
So Kirti, we often hear the phrase that some of our rights are written in the tears of our blood. But in our case, there's actually, our rights are written in the blood of women. I'm going to start today with the case of Mathura. I don't know how many in the audience have heard of Mathura. I don't know if
We've
there's
all
any.
heard about Mathura. I'm not sure about the case of Mathura.
So, Mathura, I'm not talking about Mathura, the place. I'm talking about Mathura, the woman.
Oh,
Mathura was, this is in on the 26th of March 1972. A young tribal girl by the name of Mathura was raped by two police officers in the police, in the vicinity of the police station. And how did this come about to happen is, it's an interesting story because Mathura was in love with a boy called Ashok, who she wanted to marry, was a higher caste boy. Mathura's brother Gama was very upset with this. So, what he does is he goes to the police station to lodge a complaint against Ashok for the charge of kidnapping because his sister was a minor. So the police called both the families in, and after they'd stopped, finished with the questioning, they told everybody to leave. And just while they were leaving, they asked Mathura to stay back. So, can you imagine the temerity of the police? The family is waiting outside the police station. They take Mathura to the backyard. Both these men, Tukaram and Ganpat, they rape her. Ganpat actually rapes her. Tukaram, I think, was too drunk, so he digitally rapes her. And the family then gets suspicious because they put the lights of the police station off. So they're wondering what's happening. They come to the backside of the police station. They ask where is Mathura. They said she is left. But then Mathura emerges and tells them what has happened. So they take her to a doctor. The doctor examines her and says, yeah, she's been raped. And imagine their horror because they have to go back to the same police station to now lodge an FIR.
so
And
she
as
was raped in the police station itself.
was raped in custody. And so when she goes back to the police station, of course, the police doesn't, register the FIR. So and by then, there's a lot of noise and people start collecting. And then, there's a bit of, the tempers are, they're raging a bit and people threaten to burn down the police station. That's how the FIR comes to be registered. But this is only the beginning of the horror story. Uh, what happens is the trial court assassinates the character of Mathura. And the actual wording the session court uses is Mathura was habituated to sexual intercourse. So both Tukaram and Ganpat are acquitted. The matter goes to the Bombay High Court. At the High Court level, and I must acknowledge, because remember we are in the 70s. So the Bombay High Court says that passive submission is very different from consent. And they said that, in the case of Mathura, imagine her situation, because look, just put yourself in her position. Her brother has just lodged a complaint against her, the man she wishes to marry, on a kidnapping charge. She's under, this is a position of authority of two policemen who, her husband's liberty depends, is in the hands of these two men. So they actually draw this distinction. But the matter then goes to
When
the
you say
Supreme.
they draw this distinction, so is this the first time they're talking about consent?
In a sense, yes. It's really the because remember, this is the first time uh, the court is, in a sense, struggling with. I mean, the concept of consent is absent. You see, because I mean, if you're told,
That's what I understood
yes,
from the Mathura one, is
because
that the concept of consent is what has actually been also discussed and talked about.
absolutely. So, sorry to deviate a little bit, but many of you will recall the film Accused. Do you remember that film, which was on? It's actually a story of a rape victim in I think it is a Latin American country where this rape actually took place and they made it into a film, where a woman is provocatively dancing in a bar, and she's gang raped on the I think the bar table or something of that sort. And that's the first time the message to the world goes out that, even if she was provocatively dancing, she's not asked to be raped. It is not permission for somebody to rape somebody. So I mean, we're in the 70s, and for the high court to have drawn this distinction, I think was very creditable at the time. But then Mathura's matter went to the Supreme Court, and they overturned, they did not agree with this passive submission theory. And here's what the Supreme Court said, and I'm going to read out. It says, uh, there were no injury marks were found on Mathura's body, and their absence goes a long way to indicate that the alleged intercourse was a peaceful affair.
Hmm.
So, but Mathura's verdict led to wide-scale protests. So, Kirti, just one moment. This light's blinking. Would you give me 1 second?
No problem. No
Let me.
problem. Go ahead.
Christopher, Sita, this light's blinking. I'm
In
sorry.
Mathura's case, if I'm summing up correctly, and please correct me, it was actually the High Court had actually taken a very forward-looking judgment, but the Supreme Court then went back.
It, yeah. But why Mathura's case became very important was because there were wide-scale, spontaneous protests, largely led by women's groups. Also, Professor Upendra Bakshi and two other Delhi University professors wrote to the Supreme Court. And as a result of this, the government was pushed to bring the first path-breaking law on rape in the country. Now, I'm not going to get into technicalities, but I'll explain to you broadly what happened. The legislature in the parliament, when the amendments were brought about, they created these categories of rape. Uh, in certain instances, for example, custodial rape, gang rape, rape of a pregnant woman, or rape of a minor child, they changed the presumption. So in these sort of aggravated rapes, if a woman said that there was no consent given, then it would be assumed that it was rape, and the burden of proof for discharging, for proving their innocence was now on the accused. Also, a minimum mandatory sentence for 7 years was made for rape, and 10 years for aggravated rape cases such as custodial rapes. This was the very first landmark reform that came about in the rape law. So, there was a change in the law, but on the ground, really nothing much had
Even
changed.
it doesn't seem like nothing has changed now. So we're sitting here in 2021, we're talking about 1972. I mean, has anything changed, Payal?
I don't know, and I think it's a lot of it, a lot of. Actually, what over the period of time you'll see that there has been a lot of amendment to the law, but what we're really fighting, so Kirti, we're fighting the misogyny and the patriarchy on a day-to-day basis, and this onus. We keep saying that the patriarchy is in the society, but it's also to a large extent in our own minds, and those barriers, until they are really broken, and it's really in our hands, real equality is not going to happen. We're going to keep this cycle is going to continue to keep happening. So
And
yeah.
what about these other cases like Suman Rani, Banwari Devi, of
I,
course,
I, I'll
Chawla?
take you through them, because see, with Mathura, there was a reform in the legislation, but the question of the chastity of the woman, she was of the right character, continued to keep coming in. So in effect, what you're saying is a prostitute could never have been raped. She has no right to consent. And then in Suman Rani, which was just 6 years after the judgment in Mathura, she was another minor girl who was again raped by two policemen in custody. Now, the Supreme Court, the matter goes to the Supreme Court. The Supreme Court, remember that 10-year mandatory sentence for the aggravated rape, which I just spoke about? They, in the exception to that, they reduced the mandatory sentence to 5 years. And here's what they said: there were no injury marks on her body, and she was habituated to sex, and the men were acquitted. And again, there was a large-scale protests in the country. This time, it led to a review petition. The Supreme Court in review did not enhance the punishment to 10 years, but they made one observation, into my mind, that's why Suman Rani's case is very important. They said character, reputation, or status of a victim is not a relevant factor for consideration by the court while awarding sentence to the rapist. Now, a lot of people said the criticism of this was these are just words. But
Yeah,
remember,
because they didn't change the sentence. So even though they put these words, they still went back and said, okay, only 5 years.
yes. So there is a critique of Soman Rani, but the way I look at it is, what is that term that you have in economics, the trickle down economics? So words of the Supreme Court matter. And once those words have come in, it sort of has this thing of trickling down and hopefully to society as well. So I mean, then it was a landmark in the sense because it then led to later lawyers couldn't question character. They couldn't bring in
Whether he's wearing a short dress, XYZ, out in a bar. I mean, I'm bringing it to today's terms because these are the first things they still bring in, though.
it- yeah, but it's not permitted in court. So these sort of remarks are no longer permitted. So that's why I say that Suman Rani was in and of itself an important case because of the words that the Supreme Court had spoken. But 2 years later, there was the rape of Banwari Devi. And who was Banwari Devi is very interesting. She was a woman from the lower caste, but she was a social worker and she worked for the Women's Development Program in Rajasthan. Now, she was trying to stop child marriage in her village. So, as revenge, 5 upper caste men gang raped Banwari Devi. Of course, the men were acquitted, and the court said the accused were respectable persons of higher caste and they could not rape a woman of a lower caste.
Okay. And
That,
what year was this now? This is 2 years later. So we're still
just 3
talking in
years
the
after
70s.
Somajani. Yeah,
So this is
to,
like in the 80s,
we're,
late
yeah,
70s, early 80s.
yeah. We're actually in the 90s.
Okay.
So, but what happens with Banwari Devi's rape is an NGO known as Vishakha files a writ petition before the Supreme Court. And they ask for guidelines on sexual harassment.
Okay.
So the court and now has a daunting task in front of it because the courts interpret the law, they don't legislate. They can't legislate, right? And we had no law on sexual harassment in the country. But Justice J.S. Verma, God bless his soul, he came up with this absolutely innovative, sort of, how do you say it when you bend the law to your advantage? India was a signatory to CEDAW, which was a convention of elimination of all forms of discrimination against women. So he used that and said it's an obligation for us to have these guidelines. And he, in the famous decision of Vishakha, he put down guidelines and he said that these guidelines will have the place of law until the parliament legislates. So
So
he
would
gave
I
us,
be also asking a question that the guidelines came out in 1997, but the legislation took until 2013 to come about?
absolutely. So we had to wait 16 years till POSH happened in 2013. But Justice Verma protected us because those guidelines had the force of law. I mean, and let me tell you, Vishaka came under a lot of attack from everywhere, saying, the courts now interfering in legislative space. But to my mind, Vishaka has been an absolutely landmark, path-breaking judgment. Now, Vishaka was followed by Sakshi. Sakshi was another NGO that filed, a writ petition before the Supreme Court. Now, what they did in Sakshi, what they asked in Sakshi was an expansive definition of rape. It'll shock you to know that rape, until very recently, meant penile penetration. So anything short of penile penetration would either go to 354, which is outraging a woman's modesty, or then have to be tried under 377 as unnatural sex. So in Sakshi, the petitioners asked the court, please expand the definition to have digital rape, because it can happen. People put objects in, they do all kinds of things, and they can be not just the vaginal penetration. There's anal penetration to any crevice. The court in Sakshi said, look, we can't take on the job of the parliament. This is really, so we are not going to do it. But what the court did in Sakshi was it asked the law commission to to draw up a report based on what the petitioners were saying. And the other good thing that happened in Sakshi was that the court also laid down certain guidelines for cross-examination of minors who were victims of sexual abuse and rape. For example, you put a screen while you're interrogating the child so that they don't have to see the accused. This formed, then became the basis in a sense for legislation of uh, the promulgation of POCSO, as well as the 176 Law Commission report made many recommendations. But that was in 2000, but that didn't see the light of day until, and we had to wait for the horrific rape of Nirbhaya, which I think is on the conscience of, I mean, everybody knows what happened with Nirbhaya in 2012. I am not going to get into the details of it, but the government constituted two judicial commissions. One was headed by Justice Usha Mehra. And
That was the one that you were.
yes, that was the one that I was part of. So, Justice Usha Mehra's commission recommended safety norms. So, one of the recommendations the commission made was the safety app. You've seen these ads for MySafe. And so that was one of the recommendations of the Justice Usha Mehra commission. The other commission was headed by Justice J.S. Verma. Remember the Vishaka judgment? So Justice Verma was then alive, and along with Justice Leela Seth and senior advocate Mr. Gopal Subramaniam, they did absolutely path-breaking work in terms of recommendations for further amendments to the rape law. And finally, the Criminal Law Amendment Act of 2013 came about, and we had now most of the suggestions of the Justice Verma committee were taken. So we had an expansive definition of rape, which included now all forms of any kind of penetration in any crevice of a woman. It also talked about that, if during the rape, the death of the woman occurs or she's left in a vegetative state. Many will remember Aruna Shambag, who was a nurse who had been raped by the ward boy. She was left in a vegetative state for 42 years. She died of pneumonia 42 years later in a vegetative state. So in these cases, it is now the accused can actually be given the death penalty, which is in India, the standard for the death penalty is rarest to the rare. So if a rape victim dies or is left in this state, they can actually be given the death penalty. Um, Another interesting provision was added, which was for sexual harassment in the Indian Penal Code, which said that because POSH deals with workplace harassment, so there is sexual harassment outside the workplace can now be dealt with under the Indian Penal Code. And also the punishment for outraging a woman's modesty was enhanced to 3 years, between 1 to 3 years. So that's essentially been our journey to get reform on our rape laws.
So we are seeing this journey. This journey has taken 50 years, but a lot of us feel that are we even there yet? I mean, how much more work has to be done? Because something like what the Bombay High Court has done or has made a judgment, how do we make sure that these things cannot happen or do not happen?
You know, Sukirti, people here are familiar with the Me Too campaign. The Me Too campaign, what is the Me Too campaign? The Me Too campaign is not to say that because I say somebody sexually harassed me, the person should be deemed guilty. What are we fighting for? We're saying that when a woman accuses somebody, just extend us the courtesy to listen to. But and these barriers are across the board. These barriers across the board by men, they're against women. If a woman comes forward, the first reaction is to say, oh no, actually no, it can't have happened. So if I were to actually say I was assaulted by X and my head's bleeding and I go to the police station and I go there, there's no eyewitness and said, X assaulted me, I was hit on the head, the police is not going to say, madam, I don't believe you. They're going to pick up the phone and they're going to call up X. But if I say that X sexually assaulted me or I was raped by X, the first reaction is for everyone to say, but this can't happen. No. That's what the campaign is about. And at least, women, we have to start believing when someone comes to you and says, listen, I've been a victim of domestic abuse, I was sexually assaulted, I was harassed, just extend the courtesy of listening and believing. And unless that happens, forget about anybody else standing up for us.
So, one question I definitely want to ask you, because this is a very important one, because we've touched on it. I mean, the domestic violence, because when you say, when we can see the scars on the body, yeah, you've been hit or you've this, but when we talk about even marital rape, when you can't see the physical scars, where, I mean, why is it so disproportional that, yes, if somebody has beaten you up, great, I'll write an FIR. But if I do say that, yes, I have been maritally raped, that still is questionable.
Oh, it's not
And,
questionable.
and that the law will not step in and they say we cannot put policemen outside every bedroom.
So let me tell you something. Marital rape is not only illegal in the country, it's actually legal. And I want to read something for you.
When you say it's actually legal, meaning it is actually
It's legal by law.
by law, meaning if a
I'm
husband rapes a wife, nothing can be done.
Oh no, so I'm going to read something for you. So please
Sure,
hear.
please do.
So the rape law has this entire, the section 375. And then there's exception 2, which says sexual intercourse or sexual acts by a man on his own wife, the wife not being under the age of 15 years of age, is not rape. Thankfully, this 15 years has been now made 18 years thanks to a writ petition that had been filed by Independent Thought. So they changed that 15 years to 18 years. But I don't understand this concept that a wife can't be raped by a husband. Why not? Why not? Because eh, and this is the thing about consent. Consent can be withdrawn at the nth hour when two people are standing absolutely, they're ready to indulge in sexual intercourse. Consent can be withdrawn. And I think that one of the biggest issues, and people are able to disconnect between uh, acts of sexuality and acts of rape, is because we continue to keep calling all offenses sexual assault, sexual touch. Sex is something that is between two consenting adults, and the operative words being consenting and adults. So, firstly, a child is in no situation to give consent. You don't allow them to enter into a contract. How do you allow them? You can't. A child can't have sex. So any form of sex with a child, it's not really sex. That's assault in its abuse. The other thing is the operative word is consent. Whether someone's married or they're unmarried, withdrawal of consent is rape. It's an act of violence. It's something that children have to be taught from when they're really little, that there is a difference between a violent act and sex. These are two different things. That absolutely in two different buckets. Now the question that keeps coming up is, what will happen to the poor man, because every wife will say that she was raped by him. uh, Excuse me. People don't get up and say they're raped by their husbands. That does not happen.
But why are the laws drafted in such a way? And I think people have also that they're so gender biased also. Like we're thinking about what will happen to the man, not
Exactly.
what will happen to the person who has been put through this trauma.
It's indoctrination. So Katie, there's nothing else. There's indoctrination from day one to believe, this sentence, boys will be boys. What the hell does that mean? What is boys will be boys mean? Boys are human beings. No is a no. You have to act like human beings, not animals. It's not like you have a pass big, or that you have greater sexuality than women do, or if you're in a state that you're aroused, you can't hold back. What does it mean? We have to stop using language that gives men a pass. And unless this indoctrination changes in our own minds, and we're kind of really reinventing and rethinking every day of our lives, reminding ourselves that I call it the problem of the tetrad hex. It's you're sort of burning yourself at both ends of the stick. You get paid half your male compatriots at work, you do double the work at home. So it's coming at you from four sides. And then there is uh, this constant fear of, between travel from home till the office, somebody is going to touch you, somebody is going to rape you. You reach office, there is the entire gamut of sexual harassment that you may have to deal with. There's misogyny at the workplace. We were constantly talked over, and we have to behave like women.
I know, but I want to ask you a question now. But do you think the Supreme Court acted so expeditiously, especially now, because of the voices that were raised? And every time when you've talked about that the judgments have come about or changes have come about, is because women have powerfully, or society, I shouldn't say just women, society has said, I'm going to raise my voice. It doesn't matter what the judgment is coming out. And then we see action is actually happening.
Yeah, because that's what democracy is about, Suketi. And don't
But
forget.
you would feel in law there shouldn't be democracy. Law should be law. But it seems like we need to still fight. And if we're not fighting with our voices and we're not raising them and we're not calling out foul, that, things like this would just get buried under and continue.
So on both points you're right. So one, of course, is I don't want to sound holier than thou, but don't forget, we come from the land of the Mahatma and Dr. Ambedkar. We have a constitution. We're a vibrant democracy, and of course you should raise your voice. But the second thing also, we do have a constitution and we're a constitutional democracy. What that means is the rights of minorities have to be protected. And uh, women have protections under the law. Remember, you have the protection of Article 14, which is the right of equality. You have the protection of Article 15, which means that the state can make laws for women that are, in their favor. We have now, because of the struggles that we spoke about, pro-women legislation. I spoke about only rape, but in every area, we've had, we've got pro-women legislations, but those you also require, and we society of course has to change their thought, but women also have to fight, and the right recourse and the remedy is the court process. It's time consuming, it's difficult, but remember that the law will only get better the more and more you assert and the more you're fighting for your rights.
Rajni makes a comment. There have been recent statements. Why raise the age for marriage when women can produce at 15? You hear even our politician making such comments. So, even when we're talking about what should be the legal age of marriage, should it be raised? We're living in almost such a very different societies.
Yeah, I mean, we have to vote better. We definitely have to vote better and have better people in parliament for sure. But uh, that aside, I also think that, yeah, of course, the age for, there has to be a particular age. Also, from, just see it from a thinking point. Marriage is a lot of responsibility, and there's no education at all. At all. Women get into the idea of marriage because this is storybooks sold to us since we're little, the knight in shining armor and that beautiful dress, and the whole life you're preparing for that one day without any any education on what's to come. No education on the fact that, you might want to have a conversation on finances. How your finances are going to be dealt with post getting married. Is your husband going to involve you in financial conversations? What are the responsibilities? How does domestic work get divided? It's all just thrown at you.
No, totally agreed. I mean, I think a couple of questions that are coming up. One is about implementation. The second is about, has the Supreme Court ever stepped in so quickly? And I think there's some other famous judgments that I would like you to touch upon after you answer these two questions.
So, sorry, what was the question
The
again?
first question is, has the Supreme Court ever stepped in so quickly?
No, I mean, I can't. I'm sure there are lots of instances where the Supreme Court has, this is particularly because this was a statement by the Attorney General and they, stayed it. But the Supreme Court has acted on many occasions. May not, I can't recall anything on the top of my head on women's rights at the moment, but I'm sure it has.
The
This was
second, the question that is about implementation. That yes, our legal system may be progressing, but where is the implementation?
it's certainly a problem, and that's really a topic of another conversation. And I have very strong views on the blurring of lines between the legislature and the executive in our country, and implementation of laws is certainly a problem.
Yes. Now you've spoken about many famous judgments, but you didn't mention the Shah Banu one. Wasn't that also a very important case in our history?
Oh yeah, of course, but that was not with regard to rape. Shah Bano was with regard to the Muslim rights, the right of maintenance of for Muslim women. Now, what had happened in Shah Bano was, there was a 70-year-old lady who had been divorced by her husband with 5 children. And after the divorce, he used to give her, I think, an amount of 200 rupees, which he stopped paying. So she moved the court under, not under the Muslim personal law, but under section 125 of the Code of Criminal Procedure. There was a little provision sitting there for maintenance under the Code of Criminal Procedure. So the trial court awarded her, I think, a sum of 25 rupees under the CRPC, which matter was then challenged. The High Court enhanced it, and the matter went to the Supreme Court. And in a landmark ruling in Shah Bano's matter, the court said that look, as far as personal laws are concerned, those are, governed by your religion, but as far as the criminal law is concerned, that applies across the board. So she will be entitled to maintenance under CRPC. And what was supposed to be a progressive judgment, there was a furor in the country. It finally, the government had to backtrack, and they actually came up with this legislation called the Muslim Women Protection of Rights Divorce Act under 1986. So what this legislation said was that the maintenance which will be granted to a Muslim woman will be for the period of iddat, which is the schooling off period after the divorce. It's a 3-month period, and and the meher which she gets at the time of the marriage, that will be returned. But after that, the woman's relatives and the Waqf board will take care of her. Post this act coming in, Daniel Latifi, who was the lawyer of Shah Bano, challenged the virus of the act and its constitutional validity. So the Supreme Court refused to strike the legislation down, but what they did was they really took the fizz out of it, because they said that maintenance will not be only until the iddat period, and the man has got to maintain his wife. There's no question of her running behind her relatives to find them, and then go to the Waqf board trying to beg for money. So Shah Bano was a very, very important judgment in our history, of course, on Muslim rights. But if you want to know why else it's important, you must go and hear Shekhar Gupta does this Katta Klatter. He's done one on Shah Bano. It's a very interesting one, and I think all of you should just kind of go and see why it was such an important part of our history. I'm unable to hear you, Sukirti.
Sorry, a couple of questions that are coming now. Of course, when we're talking about maintenance, so what about just overall the divorce and maintenance laws? Where are we on that?
Well, actually, fairly progressive, because okay, so just let me first break it down. Maintenance. One way to get maintenance is under your personal laws. So if you're married, you're a Hindu, married under the Hindu Marriage Act, there's a provision you'll have to go under the Hindu Marriage Act. For Muslim women, there's the personal law is different. There's the Special Marriage Act, so you go under that. Similarly, for I think for also for Muslim women, and I think Parsis as well. I'm not sure about that, so we'll just park that. You can also seek maintenance under the Code of Criminal Procedure, which is that provision 125 that I had spoken about. You can also now go under the Domestic Violence Act and seek maintenance. So, and all of these, the important thing is that all of these legislations are independent of one another. They have a specific purpose. You can go under one, you can go under two, you can go under all of them. And seek maintenance. But the only thing that the Supreme Court has said is that it's not like you can take maintenance of each of these and the man has to pay. So what it will be is that collectively there will be one amount, and you could have got that of various courts, but that one will be set off against the other.
Okay. Some questions have been coming up, and Sunita is asking digital harassment, because now we are facing a lot of issues that everything has moved from the physical space to the digital space.
So you don't mean digital rape, you're talking about
Digital harassment also.
Yeah. So yeah, those are all the provisions exist under the IPC. So stalking, harassments. There's an entire cybercrime cell under the IT Act. So those, I mean, what's the specific question? If you ask me, I'll be able to. So in short, the protections are there under the law. And you also have an Article 21 right to privacy. There's a 9-judge bench which has now said in Puttaswamy that privacy is a fundamental right.
So now two more questions I'm going to ask you. Now, after the stay order, what's next? What happens now? So now this whole thing is said, okay, this has been stayed. What is the next step?
So I suspect. So they, by the way, there's the youth association that's already challenged the judgment, but I suspect the state will go up to the Supreme Court.
When you say the state will go up, please explain further.
Oh, okay. So what happens in any criminal law case, for the victim, it's unlike a civil case where it becomes Payal versus somebody else. In criminal law, the state fights on your behalf. So it'll be, in this particular case, it'll be the state of Maharashtra versus Satish, which is the
Okay.
POCSO case. So, because this judgment, and the fact that the Attorney General spoke in the court, uh, I believe that, I think, I mean, I'm speculating, but I think the state of Maharashtra will go up against this order to the Supreme Court.
Okay, so that's still, so there is still some ways to go yet. It is not like now that the Supreme Court has stayed the order, we know now that justice has been served or.
In one way, it has, because that the judgment is really of no effect as on date. So to that extent, but they haven't finally ruled on it, and they have to, they have to, the court will have to consider many aspects. They'll either agree or disagree with it.
Well, thank you, Payal. I know that we've covered through a lot of information, uh, but I think a lot of feeling is that despite the Nirbhaya, the Katwa, the Hathras, and now this, I guess, touch case, I mean, what, why are we still so lacking? Why do we still feel so unsafe? Why do we, as women, feel that there's so much more to be done? You've said that, okay, the legal system is there, but when we see judgments like this, it really leaves us shattered.
Of course. I mean, and don't forget that POCSO is with regard to your children as a mother. This is really scary, because this is like your worst nightmare come true, where your neighbor's taken away your child. And in some ways, it was a stroke of luck, because she found her daughter before anything else could have happened. So yeah, I share that sentiment, but again, I cannot stress this enough. Women, and if I may, here's what I think that each one of us can do. Small steps is to first recognize the patriarchy in the society, recognize that we're all part of it, take steps to do something about it. The second thing, as I said earlier, when try and create active sisterhoods, it's like going to be the equivalent of the boys club. At the workplace, don't fool yourself to believing you're part of the boys club. You'll always be the prey. So, and when women reach positions of power, don't think you're part of that club. It's your responsibility, I think, to kind of pull each other up. Remember that it's when you have what's now given the name of diversity at the workplace and at boards, you've created that one space for a woman where many women are now fighting for that same space. You've got to think about the broader perspective. When women in positions of power have to pull each other up, think about creating the sisterhood. I cannot stress this enough. Recognize one thing, that you have the power to make that change. That's not going to happen. Nobody's coming for us until we don't recognize it, and unless you are not bringing other men and women into the spectrum to think like you, it's not going to happen. uh, like I said earlier, if women are often spoken over, stop that. Think about what Kamala Harris did when she said, "Mr. Vice President, I'm not finished." Be polite, but state that. Start using gender neutral language. I heard a wonderful TED talk by this lady called Lira Boroditsky. She says, the language you speak speaks the way you think. And it's about time to start thinking using gender neutral language. Don't feel pushed to change your surname after you get married. I'm not saying don't do it, but think about the difficulties you go through. And an interesting thought came to my mind a few days ago, Sukirti. I was thinking that in same sex relationships, men and men, women and women, uh, it's not the norm to change your name. You either do hybrids, or both parties retain the name. And I thought about why is that. Because in this man woman thing, it's power play, right? You're just society expects you to do it. And I'm now starting to question, why should our children not have the names of the primary caregiver?
I know.
Why should there be why should we not be, why should we not, we should, why are we not questioning norms? So don't be afraid to uh, to be part of financial conversations. Demand to know what's the family. And so many women, when they come to me, have no idea how much their husbands are earning.
No, very, very
It
true.
comes out in that income affidavit when you have to file it for at the time of the divorce.
No, but thank you, Payal. That was an enlightening conversation. And I think everything that's been happening also shows us how much our voice matters and how much we actually need to use our voice, whether we use it digitally, whether we use it physically. But we need to start using our voice and we need to start being vocal, because these judgments not only are going to affect us, they're going to affect our sons, they're going to affect our daughters. They're going to actually create the legacy of what the legal system will be as we move forward. So, with that, any closing thoughts, Payal, before we end for tonight?
No, just more power to women, and do what you can. Start all women businesses.
Thank you. And thank you all for joining us. It was a pleasure to have you all with us. A lot of people asked. This video will be available on our Facebook page on Sipping Thoughts. And thank you, Payal, again for enlightening us and shedding light on this extremely important issue today.
Thank you, Sukirti.